of that ELC court. Habari ya asubuhi.
Mzuri sana.
Yeah,
Asante sana.
Just tell the listener who exactly is Judge Edward, and how you got there.
Yeah, thank you so much. First of all, let me start by appreciating for the opportunity. For me, it's a pleasure to be here, and I'm happy to be here. As you have told your listeners, I'm Edward Wamboto, a judge of the Environment and Land Court, currently serving at the Milimani Environment and Land Court. And my journey to this particular place, the institution of the judiciary, I joined the judiciary in 2021, June 2021. That's when we were sworn in on 3rd of June 2021. Before that, I was working with the National Environment Management Authority, where I worked with them for about 10 years. And that's when I developed a greater interest on environment and land matters. And as in Kenya, you cannot talk about environment without land. Yeah, because the protection of the land also by way extends to the protection of the land with effective conservation, sound management, and utilization of the natural resource. Yeah, so this made me to develop a greater interest on environment and land matters, and then that's when I applied and I joined the judiciary as Environment and Land Court judge, and I've been serving in Milimani ever since then. It has been an interesting journey and a great opportunity to hear disputes in Kenya, to serve people, to try and resolve the complex disputes and issues. And it's something that I've enjoyed doing for the last 2.5 years. Thank you.
Habari ndio hiyo, if you always nurse dreams as sitting in a courthouse and, being called your honor and such. That is how you get there. Now, before we delve deep into this conversation, there is an activity courtesy of the ELC court that is coming up.
Yes.
Yeah, right. Yeah,
thank you. Actually, why I'm here, the key purpose of my attendance here, first and foremost, is to tell Kenyans of this activity that we are launching on the 5th of February 2024. That is this coming Monday. So what we decided to do as Environment and Land Court here in Nairobi is that over time, since the establishment of this particular court in the year 2012, owing to the promulgation of the Constitution and the land question that was posed to Kenyans when they were enacting the new Constitution, was trying to address the many challenges that the country was experiencing relating to land. So the court has been in existence for 11 years now, and to a greater extent, of course, they have tried to resolve the land question and the land disputes in Nairobi. But still, we have been having these challenges. And it appears that in as much as we try to resolve these disputes, we still have a myriad of challenges that are emerging and coming up. So the Environment and Land Court in Nairobi here decided to have a different view or approach to try and address these particular issues. So we decided to form a working group, which is known as the Nairobi Land Justice Working Group. And this particular group will be focused on expediting land justice within Nairobi. And we try to address this through bringing all the stakeholders together, who are the key players in the land sector, ranging from the Ministry of Lands, ranging from the physical planners, ranging from the surveyors, ranging from the lawyers, and even the community itself. And we decided to start in Nairobi because the Nairobi location is the one that is central and critical, and the one that receives the highest number of cases and disputes, and the most complex ones. Yeah, so we have brought these stakeholders together, and we'll be sitting together to come up with a way of expediting and resolving the complex land disputes that we have in Nairobi. And by doing so, we have also zoned and classified Nairobi into 5 zones. If I can just mention some, beginning with the area of Karen, Langata, Kibera, where most of their disputes will also be unique from other places. Then the second zone is this area of Runda and Westlands and Lavington area. And then, of course, the third zone is Eastleigh, Starehe, Babandogo area. And then, of course, the fourth one is this area of CBD, Central Business District in Nairobi. And then the last area of focus is the area of Eastlands, Embakasi, Njiru, and Dandora. And you'll find that this particular area we have observed that they have a unique pattern of land disputes. If I can give an example of Nairobi CBD, you'll find that most of their disputes relate to renewal of leases which are about to expire, and many disputes relating between tenants and landlords. Yeah, so you find that whenever any case that comes to you as a judge from Nairobi CBD, 80% chances the dispute will be resolving around that particular issue. When you go to Embakasi, Njiru and other areas, you'll find that most of the disputes relate to the land buying companies. You've heard of like Embakasi Ranching and others. So you find that in one way or the other, the disputes stem from that particular place. So we are trying to go to the central core, the root cause of these particular disputes, as stakeholders, as the key players in the justice sector, to try and address this particular problem. And our goal is that once we address this root cause, to a greater extent, we'll have resolved a number of land cases here in Nairobi. And the Nairobi Justice Sector Working Group has a time span of 2 years. Once it's launched, the key focus will be on those particular cases, and you try to entrench a uniform platform or resolution mechanisms for addressing these particular disputes in future. And then the other basis for this was that, of course, a judge would hear and determine these disputes, but after a few years or few months, it comes back to court. The reason is that probably you can come to my court, we hear your case, you get a judgment, but once you go out with it, it turns out that there's other parties who are also involved or have an interest in that particular land that did not participate in the proceedings. And then again they come back to court and say, oh, there's a judgment here, but I'm the affected party, I was in the suit property, I was never involved, I never participated. We still come back to that square one. So now with this particular platform, it will be easier for each and every one of us, and also most of these particular people, and ultimately for the benefit of the citizens of Nairobi. So that now in future, after this Land Justice Working Group is done with its work and mandate and executed successfully and even achieved its outcomes, we'll be benchmarking and making reference that indeed at this particular point in time, we had this particular program and this particular group, and this is what they resolved. So this should be the basis of resolving that particular disputes. So that is the main focus.
So after the zoning into different groups,
yes,
you could just paint a picture of what will be going down.
Yes.
Will there be a professional from the court
Yes.
that is taking people through what they're supposed to be
Yes.
knowing, or some legal proceeding or something?
Yes.
How will it?
So
be?
basically, what will happen after the zoning is that this justice, the Nairobi Land Justice Working Group, with its composition, because I said it will have various people, that is from the national government, from the county government, the county will be represented, professionals from the survey, and then the lawyers themselves, and members of the community. If I can give example like Embakasi, you'll find that we'll try and reach out to, we have those, you can call them like the elders of that particular area, some people who have a history of where these disputes emanated from. Because you realize that when you trace this particular dispute, you'll find that at a particular point in time, that was when these disputes emanated and escalated up to the level that they came to court. So they'll be coming up with ways of resolving them to an extent like they can identify, like for example, the initial setup of the Embakasi ranching. What was their goal? What was the objective? What was the initial master register that they have? Who are the genuine relatives of that land? Was their process followed? What were the issues that were left out? What were some of the challenges that they failed to address at that particular point in time? And then they'll sit together and deliberate. It's more so like an alternative form of dispute resolution mechanisms. And then whatever they decide, they'll present to this particular committee or the task force, and then they'll be able to adopt and consider if it's something that is workable or if it's something that is doable that can impact the future resolution of disputes. And then now on the basis of that, it will be able to reduce to a greater extent the number of cases that will be coming to us, before us. It will also be able to reduce to a greater extent those ones that are pending. Because once they have an effective way of resolving those particular disputes, then people will say, our disputes have been resolved because these are the parameters that parties have agreed, and I'm assured that if it's adopted, then I don't need to proceed with this matter in court. So that's what we're looking forward to. And the reason is that, over time, land cases take a bit of time to resolve. Of course, we are still dealing with cases that were filed earlier, and even as we speak, every time people are still filing cases. So we are trying to reduce that particular backlog and even escalation of these disputes. So that's where we are focused at.
Access to justice means that everyone, no matter who they are or how much money they have, their social status, should be able to get a fair solution to their legal problems. And it's about making sure people can use the legal system to get help that they need. And one avenue of accessing justice is through a courthouse, a court of law. Cases taking too long in court to be resolved has been an impediment to access to justice. And so when we narrow it down to the Environment and Lands Court, what do you feel contributes to this problem? And how can these challenges be addressed effectively?
Okay.
If there is,
Yes.
we might even assume there is a backlog of cases at the ELC, while in reality there is not.
Yes. Actually, access to justice is an imperative. It's a key principle and right enshrined in our Constitution, pursuant to Article 48. In essence, the state and of course all the institutions of the state and the judiciary to a great extent are supposed to ensure that each and every citizen of Kenya has a platform or is effectively able to access to justice. And this implies the availability or ability to access court or any dispute resolution mechanisms and to have his or her disputes resolved. Yeah. So while I'll say that the National Council on Administrative Justice, which also brings all the justice sector players together, has done a lot in ensuring that there's access to justice to all citizens. Of course, there's still some challenges here and there. And one of them emanates from, first of all, the knowledge and awareness on the appropriate forum or where to go. And this could be hinged to some extent by also the literacy level or the illiteracy level. So you find that some people up to now, they don't have that knowledge of exactly where to take their disputes for resolutions. But those that have the knowledge and the platform, of course, they're able to access justice. And of course, also access to justice will imply that once also these people have accessed the court, they're also able to have their dispute heard and resolved within the earliest or even possible, shortest time possible, so that at least they can move forward with their issues. You have seen that just to promote this and ensure that this is done, the judiciary has even tried to launch accessibility of court services at Huduma centers. Yeah, so that whenever these Kenyans go to anywhere that there's Huduma centers, they can be able also to file their cases online. They can be able also to pay for their fine. They can be able also to seek any information on any pending cases in terms of its position. And even they can be able to even inquire or ask any queries on whether when their matter is coming up next or even when possibly it will be heard. So all those are issues that the court has been doing to ensure that there's accessibility of justice. And also, most importantly, as you're aware, the current Chief Justice also came up with the social transformation to access to justice, which of course is just a blueprint that ensures the most vulnerable people have been given a very good platform and an opportunity to access this particular justice or courts so that they can have their disputes resolved. Yes.
So due diligence.
Yes.
Most times we are being told, it's making sure that you have comprehensive knowledge about a thing or an idea or just something. Now, due diligence, when we talk about land matters,
Yes.
What does that mean?
Yeah.
And unaweza tu tuelezea pia as a judge, what does it involve? Because I'm sure this is some of that or part of the knowledge you look at when you listen to an issue.
Yes. Yeah, in a system that we have currently and the issues that keep on emanating, of course, due diligence is very, very important in any land transaction that you're doing. And basically, in simple terms, due diligence means that before you engage into a transaction, you are satisfied that indeed that particular transaction and the land that you want to buy or whatever you want to undertake, even if it's charging your property, you have the right information to verify that indeed this is either a legitimate transaction, or rather this is a legitimate piece of land, or rather this is a legitimate document that you have. It's just investigating and confirming that whatever you have been offered is the true reflection of the position on the ground. And there are many ways that you can do it. Of course, if you're a layman and you can afford a lawyer, it's normally good to engage the professionals. So the lawyer will assist you in doing it. The lawyer will reach out to the land registry to do a search. Even the lawyer will be able to do a site visit just to confirm that indeed that particular land exists. They'll also be able to reach out to the Directorate of Survey and obtain a map to confirm that indeed this is the location, physical location of the land. So it helps you to avoid situations whereby you are only buying air to be duped into something that you're buying. And there's this particular saying that, sometimes, yes, you can do due diligence. You go to the land registry, you do a search, you confirm that indeed this is the correct position. But you come back and see, you're still able to. I mean, they have duped you into that particular transaction. So they say, apart from that, you also go ahead and do a historical search or historical diligence just to confirm that this particular land, in as much as you are telling me you sold to me, before you sold to me, who else owned this particular land? And before that particular person who sold to you, who else was using that particular land? So a bit of a historical search is also very important, just from the normal due diligence that we have. And you've even seen some people saying that when you're looking for land, walk around, talk to some village elders or even some local drunkards, because they normally say a drunkard will be open to you and he'll tell you the truth in respect to that particular land. Yeah, so in the long run, it will save you a lot. Of course, it might be time consuming and a bit costly initially because you have to invest and commit some resources, but it will save you a lot for the long term. Because remember, people, we are buying this land for the long term. Yes, so that's why we keep emphasizing that it's important to do due diligence.
Now, Judge, who is a squatter?
Mm-hmm.
What makes one a squatter?
So, generally speaking, a squatter is anyone who enters into someone's land without permission and settles on that particular land and continues to use it either by way of tilling or staying that particular land. And he stays there for quite some time, to an extent that he or she accrues some rights, whether legitimate or otherwise, at that particular point in time. And as you can see, we have had several problems with this issue of squatters in Kenya. This does not mean that they don't have any rights. They do have rights. And we have had also a number of cases where the courts have decided that squatters have right to the extent that you can't just wake up and evict them unless you make alternative mechanisms or alternative options for their settlement or for a place where they can be settled comfortably. Because, you know, at the first instance, they're also human beings, and they're entitled to shelter, and they're entitled to a decent or dignified way of living. But the problems emanate now when probably there was an absentee landlord and someone comes back to his land, he wants to develop it or he wants to acquire or repossess. And then, of course, they engage other unpleasant ways or modes of evicting them. Of course, that's where problems emanate. And the Land Registration Act that we have and the Land Act that we have provides a mechanisms of how this can be done. You're expected to give them notice, at least 90 days notice. That is, if there's someone who's in your land without your permission. Then you're also expected to notify the national administration through the county commissioner or the area chief, if possible the police commanders and all that. And then after the expiry of that notice, then of course now you can commence the process of evicting them. Some maybe come to court to seek eviction orders so that you are given a platform for them to defend themselves or to present their case. And normally when these cases are filed in court, at the first time or instance, you'll want to hear their side of the story. You cannot just order eviction of someone ex parte without hearing their side of the story. And then depending on how they'll explain themselves or provide evidence how they got into their land or how long they've settled there, then of course you can see whether or not they're entitled to be evicted or not. And even when where the court orders eviction, of course they should be given adequate notice. It cannot be instant. Probably can give them 30 days, 60 days, and 90 days. And sometimes even when they say they want to appeal, to try a second chance of resolving their disputes, of course it's also good to allow them to proceed to appeal. Because remember, eviction, it's a finality. It's like you're removing them completely from their land. Yeah. We have also had instances where squatters are moved to court by way of adverse possession, claiming that they have been in that land for more than 12 years and they need to acquire some rights and to be settled in that particular land. So the Kenyan laws allows adverse possession only on private land, but not in government land, because you cannot be an adverse possessor on a government land. That is prohibited. Yeah, but for a private land, of course you can get, and most of people have been able to get orders of adverse possession in respect to private land. There's normally a misunderstanding, because you see at some point people have settled in that land and then later on after 10 or 20 years they're evicted from government land, and then people start saying, oh, but this land belonged to the government, they didn't know it belonged to the government, and why are they being evicted? It's simply because our laws does not allow you to accrue rights as an adverse possessor in public land unless it's converted to private land.
Yes. What about community land?
Yeah, now for community land they can accrue some rights so long as they're able to say and identify themselves as members of that particular community. And as it is also, most of the community lands have not been titled. It's when they're trying to do them in various places, because this is something that is done over time to ensure that indeed the relevant members or residents or inhabitants of that particular community are able to benefit from this particular land. Yes.
How would you rate the performance of the ELC court since its inception in 2012?
Okay. I would say the ELC has done tremendously well. And then, of course, we also have statistics to confirm this and back up this. Remember, when ELC was established, a number of land matters which were initially being heard by the High Court were not moving fast or were not being heard expeditiously as was expected. And you know, when land disputes are locked up in court, it affects even the economy of the country, because maybe people want to use this land to charge them to acquire some property, to acquire some facility, be it credit facility or loans for development, or even some want to sell for a particular purpose. So a number of matters in land used to stagnate. But when the ELC was established in 2012, they started dealing with these particular cases. Those that were pending were moved from the High Court to the ELC. And we can say from the statistics that I have and I have seen, they have been able to reduce the backlog as it was then up to now by 100%. Yes, so they've been able to reduce backlog by 100%. So even the number of pending matters that are over 10 years old have reduced significantly. Those ones that had been taken a lot of time to have them resolved as it was then in the High Court.
Any strategies that the ELC court has put in place to strengthen delivery of justice service?
Yes. First of all, they were able to ensure that there's wide reach in all the counties. They're trying to at least be in all the counties by through the appointment of more and more judges to hear these particular cases. And then, of course, also places that were very problematic, like Nairobi, they're also able to assign a higher number of judges to deal with them. And then also, secondly, over time, the ELC was also able to undertake what we know as service weeks, whereby judges are assigned to come to a particular station for a particular duration, be it either 2 weeks, 3 weeks, or 1 month, to hear cases on a day-to-day basis, ensure them that they are concluded. Also, the court has also been able to encourage, especially cases between family members, extended family members, to adopt an alternative form of dispute resolution, and then they just come to court with their final agreement or decision, which is adopted as an order of the court, and the issue is settled. among many, many other strategies that the court has been able to put into place.
All right, so that's how the ELC interface and alternative justice system works.
Yes.
What types of cases does the ELC consider under the AJS mechanisms?
Yeah. So mostly under the AJS mechanism, first of all, they try to consider cases pitting family members between themselves. Yeah, it could be father and daughter, father and son, mother and son, even spouses, husband and wife. Yeah. And this is because remember that first of all, these are family members. Probably they acquired this property together, or this property was given to them by either their parent or the other relative. So the best way to address this is to have these parties sit together and try to resolve this particular dispute, to find out that what is the underlying problem that warrants them to bring this particular case to court, or that has led to that particular dispute. So we try to encourage that at a very great extent. And then to some extent, we also try to encourage disputes between business, it could be partners or directors of company. Because remember, these are people who have worked together. They have acquired this property or assets together. And then, of course, they're able to be given time off. They go to alternative dispute resolution mechanism, either through a mediator or through any other appointed person. And then they're able to discuss their disputes and the issues, and they agree on them, and then they bring to court as an order, which is adopted by the court. Then, of course, can mark the issue as having been settled. Yes.
There is the notion that the National Lands Commission requires alternative justice system for land disputes, and you've rightly put it that AJS it is recommended for disputes that involve families. Right. With that in mind, and in your view, must citizens exhaust mechanisms at the Commission before approaching the Environment and Lands Court?
Yes, it is highly encouraged also that citizens try to resolve their disputes amicably or through alternative dispute resolution forums before filing their cases in court. Remember that when people come to court, of course, they come to court as a last resort where they failed to adequately resolve their disputes. And when they come to our court, the nature of our court system is adversarial. We will determine your disputes according to the evidence that you will present and the law. And adversarial in the sense that the court will not try to interrogate, rather to do like an interrogation or rather like an investigation to establish exactly who is, will just base it on what you offer us. And depending on how assertive, forceful, determined, to a great extent that you can go in putting forward your evidence, and if the law is in your favor, you will be able to at least have judgment awarded to you. And this, to an extent, leaves one of the parties hurting, because it's a question of winner takes it all. Unlike an alternative dispute mechanisms where the parties will be able to make their decision or agreement together. It's like they'll do their agreement together, they'll talk, they'll agree, they'll thrash out any differences and issues they have, and finally tell us that now, as per this particular case or land, we have agreed as follows. You take this half, you take this half. Yes, so that's why we keep encouraging them that if you can, where possible, try and resolve your dispute amicably before you come to court. Yes.
Do you think the ELC is probably constituted to handle climate disputes?
Yes.
Because now the world is moving towards the environment part of the climate part of the environment. Because most times people,
Yes.
Whenever you talk to them about the environment, what comes into mind is land.
Yes. Yeah, the climate change issues. Yeah, you realize that, of course, climate change is a serious issue currently affecting not only Kenyans, but even people in greater world. And that's why you're able to see the month of January, which ordinarily is perceived to be rain-free. We experience a lot of rain in most parts of the country. Yeah. So the Environment and Land Court, if you look at the Constitution Article 162, and even together with the Environment, Section 13 of the Environment and Land Court Act, they're also mandated to hear disputes relating to climate change. And we of late now we are having quite a number of cases relating to climate change that have been filed. Though they are yet to be fully concluded, they are still pending, and they're in various parts of the country. And this is because now people are becoming more and more aware. In fact, I've discovered that Kenyans are not illiterate as you think. Kenyans are aware of whatever is happening, and they know the issues that are affecting them, and that's why they are coming up and bringing these particular cases to us. And the court is prepared. We are ready to hear these particular disputes. Sooner or later, we'll be having one or two judgments coming out from this particular court that will be addressing the issues relating to climate change. Though in some other countries they are ahead, they have been able to address these particular disputes and even render judgment against the state or other players in respect to the issues of.
What is the current caseload in the ELC? And if you can recall, the oldest one, ulienda pale ukapata.
Yes. For the moment, our statistics shows that the current active cases nationwide relating to ELC could be about 11,600. Though in Nairobi alone, there could be about 4,000 that are still pending and active cases awaiting resolution and determination. Yeah, this shows that, of course, to a greater extent, the court has been able to reduce the backlog and address, determine some of those pending cases that had been in court for quite some time. In terms of the oldest cases, let me just point out that, the ELC was established in 2012, or rather the first judges of the ELC started their work in 2012, when we already had cases that were filed. I inquired before I came here, and I was surprised that we have one case that was filed in 1941 as one of the oldest cases that we have. For some reason, it has been pending for quite some time, and of course, definitely, as it is, the initial parties who filed those cases, I doubt whether they could still be alive, because the matters will be determined by their legal representatives or beneficiaries who have survived them over time. So the focus now will be to try and put more emphasis on those particular cases, especially the ones that are 10 years old and above, to give them priority and to ensure that they had and determine. Yes.
So now a person or an individual
Yes.
comes to court, or even a corporate body comes to court, and they of course have a land case, and now they are in front of you asking for a few prayers. So in what circumstances do they come to pray for a declaration of their rights?
Yes. Now, mostly when someone comes to court, there are a number of reliefs or prayers that you'll be seeking, and sometimes will depend with the type of pleading that he has filed. So different pleadings gives avenues for different reliefs. Like, for example, if you feel your constitutional rights have been violated, you'll move this court by way of a constitutional petition. And when you move the court by way of a constitutional petition, you could probably be seeking a declaration of violation of some of your rights. It could be right to property. It could be a right to a clean and healthy environment. It could be any other rights, as long as stipulated within that particular constitution. So the court, upon determining that particular issue, indeed will arrive at a decision or conclusion that there's a violation of this particular right in the constitution, and you hereby declare that these rights were violated. His or particular rights were violated. Of course, the other remedy that the court can offer is compensation for damages. Yeah, so maybe after finding out that indeed there was a violation of your right, the court can proceed and assess the damages that you have suffered and award you either a quantified figure or any other form of compensation that will be meted out from the court. And then we also have remedies relating to permanent injunctions, for example, that if you are seeking, for example, you want to permanently injunct someone from entering your land as a trespasser, that's also a remedy that the court can offer. The court can also give you a remedy of eviction. If you feel there's someone who was trespassing to your land, he entered there illegally, is becoming a nuisance, he has refused to leave, depending on the evidence that you will present, the court can also order eviction of that particular party. And of course, also ultimately, the court can also order costs of your suit, depending on how you have put forward your case, and if it says that you're entitled to costs, the court can order that other party whom you have sued to pay you costs of that particular suit. So those are just some of the damages and remedies or mechanisms that the court, or awards that the court can give in respect to the number of pleadings or in respect to either way that the person has moved this particular court. Yes.
A conservatory order?
Yes, a conservatory order can also be issued.
Right.
This will mostly be if someone has moved in the court by way of a constitutional petition. It's another form or another way of an injunctive order, because you seek to conserve something, or you seek to injunct, or you seek to bar someone from doing something. Yeah, but mostly used in constitutional petitions.
A judicial review?
Yes, also judicial review is also a mechanism that is available, whereby you move the court seeking mostly 3 orders. It could be an order of mandamus to compel a government entity or an institution to perform a particular function. It also could be a way of a certiorari, is an order to quash a particular decision or a particular declaration that has been made by any government or institution that you feel is violating your rights or position, or you are aggrieved against. And then it can also be a way, you can also get an order of prohibition, which is just like an injunction or conservatory order, whereby after you file your judicial review, the court can prohibit someone from proceeding with a particular action, or even from undertaking a particular action.
And
Yes.
final but not least, declaration of invalidity of a law that threatens or infringes fundamental right.
Yes.
In what does circumstances can you come and can someone come
Yes.
before your court and ask for that?
Yes. Now, for a declaration of that particular law or provision, the person must move the court by way of a constitutional petition. And the basic point or starting point of reference will be that this particular provision or law is infringing in my rights in one way or the other, and it's simply because it is unconstitutional. Remember that in our country, the constitution is perceived to be the supreme law or the ground law. So any law or any decision or any circular that is made must be in line with that particular constitution. If something is found to be contrary to the applicable provision of the constitution or existing, then of course it will be declared invalid or unconstitutional or void to the extent that is contrary to that particular provision of the constitution.
Judge,
Yes.
we've come to the end of the first hour.
Yes.
And mtaendelea into the second hour na msikilizaji, but ningependa tumalizie by just telling the listener the activity for the ELC court,
Yes.
where we started.
Yes.
Yeah, if in case somebody will join through the way.
Yes, and he missed out. Yeah.
Yeah.
Yeah, thank you so much again. Just to remind our listeners again that on Monday, the 5th of February, we'll be launching the Nairobi Justice Working Group on land issues. And the main purpose will be bringing together all the stakeholders and all the players to come together and address the challenges and complexity of the land issues that we face here in Nairobi. And these stakeholders range from the people from the Ministry of Lands, the surveyors, the physical planners, the lawyers, and even the citizens that we have in this Nairobi. And we believe that once this land justice sector group is launched, which has a mandate of 2 years, we'll be able to tremendously resolve the disputes that we have and reduce to a greater extent the number of cases that are finding their ways to court. So the event is expected to be officiated officially by the Chief Justice. We'll also have the Cabinet Secretary in charge of land. We'll also have the Governor or his representative. Then, of course, we'll even have the LSK represented by their President or their representatives who will attend. So we look forward to having this particular launch and allowing this particular group or committee to commence its work and deliver in its mandate.
Where will I know the event will be happening across, or you've decided people are divided into zones.
Yes.
But where officially will the
Yes.
Chief Justice be?
No, we are launching it here at Milimani.
All right.
Yeah, it will be a half-day event. We are beginning at 9 and by noon we'll be done. Yes.
Anybody can attend apart from the invited guests?
We have the invited guests, but we'll be able to, at the moment we have the invited guests who will be able to attend. The rest will be able to follow online, to be streamed online.
Of course, that's where Haki FM comes in.
Yes.
We'll be able to tell you what's going on.
Yes.
Mpango umefikia wapi from 9 a.m. to 12 noon.
Yeah.
Justice Edward Wamboto, I am so happy that I had you today. You know the schedule inaweza kuwa ngumu sana, but you made time.
Yes.
I really appreciate that. and I hope that you come back next time.
Yes. Thank you so much also for giving me this opportunity. It was a pleasure interacting with them. This was my first time here. I enjoyed the moment, and I look forward to attending another particular session.